Such a right has the sanction of constitutional law, and once that is recognized, the said right needs to be protected, and it cannot succumb to the conception of class honor or group thinking, which is conceived on some notion that remotely does not have any legitimacy. वही बात सुप्रीम कोर्ट शफीन जहां वर्सेस अशोकन केम 2018 में कहा। तो अब इसका ऑब्जेक्टिव प्रिज्म क्या है? द राइट टू चूज नॉट टू बी विथ वन पार्टनर इज जस्ट अ कोरोलरी ऑफ दिस राइट टू चूज वन पार्टनर। अगर मैं चूज कर रहा हूं तो उसको ये इख्तियार भी है नॉट टू बी विथ हिज पार्टनर। Society opinions on the desirability of continuation of the marital relationship, even at the cost of personal happiness, cannot be allowed to stand in the way of right to choose of either party to the marriage. The understanding that most of the world is now moving towards is that any intimate relationship irretrievably breaks down the moment either party to the relationship no longer wishes to be in a relationship for reasons that may not even be able to explain, leave alone proof before a court. Such an understanding respects the choice of each party to the marriage to choose not to be in that marriage. This is the understanding in Sharia or Muslim personal law, where marriage is an agreement between a man and a woman, and like any agreement, it can be dissolved by either side subject to settling of terms of separation, such as payment of just and equitable compensation. That is also reflected in section 125 CRPC and the protection of women from domestic violence 2005 respectively apply respective of religion. और आखिर में सॉरी दो मरतबा बोल दिया आखिर में जर्नलिस्ट कैसा, तो इसमें और एक जो आपको ये है मुस्लिम पर्सनल लॉ में और दूसरे उसमें आप देखिए शिकाक का एक वर्ड है डिसोल्यूशन ऑफ मैरिज में शिकाक का। तो बेसिकली दिस रेस्पेक्ट द चॉइस ऑफ बोथ पार्टीज टू द मैरिज टू डिसॉल्व द मैरिटल टाई। तो the vilification in public discourse and by the media of the unilateral nature of the method of divorce available to Muslims actually betrays inherent bias in favor of the religious morality of the majority, which is actually contrary to the constitutional morality as has been demonstrated in the above two cases. अब और एक बात जो लोग बोलते सक्सेशन में बच्चों को हिस्सा नहीं मिलता मुसलमानों में, हम उन लोगों को बताना चाह रहे, बल्कि मैं चैलेंज कर रहा हूं, जितने दुनिया में रिलीजन है, कौन सा रिलीजन था जिसने खवातीन को, महिलाओं को प्रॉपर्टी में हिस्सा दिया? वो पहला रिलीजन था इस्लाम, जिसने महिलाओं को सक्सेशन में प्रॉपर्टी में हिस्सा दिया। तो ये जो हाई मॉरल ग्राउंड जो लोग लेते हैं वो मत लीजिए, उनको हिस्ट्री पढ़ना चाहिए। अच्छा दूसरी बात ये है, ये तो 2005 में हिंदू सक्सेशन एक्ट को अमेंड करे उसमें कोपार्सनरी दिया गया। अब आप बोलेंगे इन्हों कैसा बोल रहे, ये सुन लो। आप बोलते कि द शेयर ऑफ डॉटर बीइंग फिक्स्ड एट हाफ ऑफ द शेयर अलॉकेटेड टू सन is not because the daughter was accorded a lower status in Sharia or Islamic law, personal law. It is in fact reflective of the nuanced thinking that pervades Muslim law and makes complete sense in context of who conspectus of the rights available to women. In Muslim law, woman is given a meher. शादी से पहले मेहर देना पड़ता। मोहम्मद साहब बोल सकते, woman is given a meher or dower by a man as consideration of entering into marital tie with him. This meher is substantial sum that must reflect the financial standing of the husband and is to be paid prior to the consummation of marriage or immediately thereafter, unless the wife agrees to delayed payment. The woman is the sole owner of the meher, number one. Husband se mil raha, which she thus obtains from her husband. As such, a woman has two sources of secondary wealth, one from her parents and other from her husband. As opposed to this, a man had only one source of secondary wealth. माने एक आदमी को inheritance from his parents and was required to incur the significant expenditure of having to pay his wife meher in order to get married. Therefore, equity demanded that shares of the son and daughter in the inheritance be fixed accordingly so as to do justice to both. इस्लाम में हस्बैंड के ऊपर जिम्मेदारी बीवी की है, बच्चों की है, उसके माँ बाप की है। बीवी अगर काम करती है, जैसा कोई मुस्लिम जर्नलिस्ट है या लॉयर है, डॉक्टर है, उन्हों जो कमाते वो उनकी प्रॉपर्टी है, उसमें हस्बैंड का कोई शेयर नहीं है। ये बात आपको समझ, ये जो बार बार प्रोपेगेंडा करते ये झूठ है, ये सच्चाई है। अच्छा, अब जरा मैं जो बोल रहा हूं जरा तकलीफ हो जाएंगी बहुत से जो लोग इस पे चिढ़ते ये सक्सेशन के ऊपर। दिस डिस्ट्रीब्यूशन appears to be inequitable when seen from prism of the Hindu understanding of distribution of property only because of perception bias. Women in Hindu society historically didn't get this right. वहाँ कन्यादान होता था, अभी भी होता। A part of family wealth had to be given as dowry to the husband as consideration for accepting the daughter. Number one, इसको कोई deny नहीं कर सकता। This dowry was given to the husband family and such did not add to the woman's individual wealth that she controlled. अगर आप डाउरी दे रहे तो बच्ची को नहीं मिल रहा, वो तो दूल्हे मियाँ को मिल रहा। यहां पे क्या हो रहा, दूल्हे मियाँ उल्टा दे रहे। In this model, the man has two sources of secondary wealth, one from his in-laws and other by of inheritance from his parents, while the woman has only one by of inheritance from her parents. In this context, fixing equal shares of the son and daughter in the inheritance may appear to be more equitable. However, even this appearance of equity is misleading. Despite the Dowry Prohibition Act 1961, the practice of dowry continues unabated in India. Each family exceeds its means in giving dowry to the husband family in marriage, both because it is seen as a reflection of status as well as because otherwise it may become ground for harassment of the daughter. After having transferred a considerable portion of their wealth in terms of money, jewelry and movable property to the husband family, to give an equal portion of inheritance to the daughters grossly skews the balance in favor of daughter and makes the distribution inequitable. The immediate consequence of this is that each family must then look to recoup this lost family wealth by demanding it from the family their son marries into, which makes dowry a self-perpetuating social evil. Once again, our constitution has taught us equality does not mean distribution of equal shares to all, but involves a more nuanced understanding of differences and allocating shares that are equitable on a more holistic view of how different individuals are differently placed. Therefore, Muslim law of succession is in fact more equitable given the complete paradigm of personal law that it sits within. And if we don't ask the majority to abandon their customary laws in favor of this more equitable system, we should at least demand and expect that Muslim law be spared the majority's clamor for uniformity. Conclusion में हमारे नोट में ये है, we urge the Honorable Commission to not to allow itself to be made a tool for political propaganda simply on account of the approaching election and drop this enterprise. However, if this Honorable Commission wishes to proceed with exercise, it must do so with seriousness and meaningful way, explaining what it means by Uniform Civil Code and placing a concrete proposal for public comment, giving adequate time for stakeholders to respond. Our country comprises of communities that are diverse and far removed. Adivasis of Madhya Pradesh, Bodos of Assam, Madigas of Andhra Pradesh, Telangana, Siddhi Muslims, Kachi Memons, Gujar Bakrawals of J&K. Our constitution gives each of them right to conserve their way of life and recognize their personal laws and customs. I would urge this Honorable Commission to recognize this legislating away personal laws to follow such unclear goal of uniformity will mean that it will undo the gains made under 73 years of working of our Constitution, where each of these personal laws have been refined by constitutional courts. Before concluding, I would reiterate that any attempt to creating a mandatory UCC today will go against Article 19, 25 and 29 of the Constitution of India and undermine the intent and purpose of founders of Article 44 itself. अब Justice वी गोपाला गौड़ा साहब को हम 4 क्वेश्चन पूछे। नंबर 1 क्वेरी था, टाइम बचाने के लिए मैं आपको आप खुद पढ़ लो वो 4 क्वेरीज क्या थे। एक था, व्हाट इज द स्कोप ऑफ आर्टिकल 44 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया एंड वेदर द पार्लियामेंट इन एक्सरसाइज ऑफ लेजिस्लेटिव पावर अंडर रेलेवेंट एंट्री नंबर 5 of concurrent list of 7 schedule of the Constitution can bring reforms of personal laws be justified though the state article has a specific limit ambit. तो ऐसे ही हम लोग सेकंड क्वेश्चन क्वेरी पूछे थे, whether codifying certain aspects of personal laws of certain communities on the basis of proposed law commission consultation paper and concern Article 44 and the same are violation of fundamental rights guaranteed under Article 25 and 29. Third, हमारा query था whether codifying personal laws under the guise of Article 44 would not impact the pluralism within these minority groups, religious groups such as Sikhs, Buddhists and Jains, who are governed by provision in Hindu law. Fourth, whether Uniform Civil Code as contemplated under Article 44 of the Constitution of India would not adversely impact the legal status of Hindu undivided family as provided in Hindu law. Fifth, whether the statutory enactment of Uniform Civil Code by Uttarakhand state in exercise legislative power would not be contrary to Article 44 of the Constitution of India as it has jurisdiction throughout the territory of India. तो ये पहले लास्ट क्वेश्चन जो है ना, आप उसको पहले ले लेते हैं, जो उत्तराखंड का आजकल बहुत वो चल रहा है. Honorable Justice V. Gopal Gowda retired साहब क्या बोल रहे? Can a state make a law? State माने state government make a law on UCC. Uniform Civil Code essential refers to a common set of laws governing personal matters such as marriage, divorce, adoption, inheritance and succession as per Schedule 7 of the Constitution. Such subjects come in concurrent list, entry number 5, wherein powers to legislate vest with both Parliament and state legislatures. Accordingly, the state legislature may introduce amendments to the personal laws enacted by Parliament, but it cannot be stretched to include that enactment of UCC for a particular state. तो उत्तराखंड का UCC नहीं बोल सकते उसको. If Uttarakhand or any state government brings any such legislation, it will require presidential assent under Article 254 of the Constitution of India. UCC in Article 40 of the Constitution mandates UCC throughout the territory of India, which was confirmed by the then Law Minister in February 2022. This constitutional position is further confirmed by the manifestos released by political parties. For instance, UCC was a part of a manifesto of 2009 general elections, but was not specifically highlighted in the manifesto of the party of Uttarakhand Assembly elections. Therefore, I am of the view that Uttarakhand state government enacting the statutory enactment Uniform Civil Code is not sustainable in law. ये अब आपको जो 4 क्वेरीज जो हम पूछे थे उसमें से इम्पोर्टेंट मैं आपको बता देना चाह रहा हूं, जिसमें गोपाला गौड़ा साहब वही बात बोले जो हम अपने नोट में दिए कि बाबा साहब अम्बेडकर क्या बोले थे आर्टिकल जब ये आर्टिकल 44 आर्टिकल 35 था, डिबेट हो रही थी. फिर उन्होंने ये भी उसमें लिखे अपने ओपिनियन में, श्री BN Rao, द कॉन्स्टिट्यूशनल एडवाइजर टू द कॉन्स्टिट्यूंट असेंबली स्टेटेड, डायरेक्टिव प्रिंसिपल्स आर इंटेंडेड एज मॉरल परसेप्ट्स फॉर द अथॉरिटीज ऑफ द स्टेट. They have at least an educative value. The great jurist Sir Ivor Jennings thought they were only pious aspirations. Here, Justice V. Gopal Gowda said the idea to adopt one code for all personal laws was considered antagonistic to the Article 19, that is at present Article 25. Secondly, उन्होंने ये भी बोले, several articles, Article 15(1), 16, 25, 26 and 29 are embedded in the Constitution with clear intention to protect religious freedom and customary rights. Likewise, Article 26B of the Constitution ensures the freedom to manage the affairs of religion. Article 29 defines the right to conserve a distinctive culture. और important point जो Honorable Justice V. Gopal Gowda साहब हमारे legal opinion में ये भी दिए, जजमेंट्स का हवाला देके वो ये बोले, perusing this judgment, it's obvious that the court has absolutely no idea. ये एक जज लिख रहा है. Perusing these judgments, it is obvious that the court has absolutely no idea what a UCC looks like and what such a court should do. In each case, it has been offered as a panacea for a particular issue with which the court was faced, as though the only problem with India's personal law is not their misogyny or obsolescence, but the lack of uniformity. The court in all these cases cling to Constitutional Directive Article 44 as it were a clear articulation of the idea what UCC is. फिर जस्टिस गोपाला गौड़ा साहब 371A, 371G का हवाला दिए, नागालैंड, मिजोरम का. और फिर अपने ओपिनियन में जस्टिस ऑनरेबल गोपाल गौड़ा साहब ये भी दिए लिखे हैं इवन द हिंदू कोड, मैं इसको छोड़ रहा हूँ, बहुत चीज़ें आप पढ़ सकते हैं बाद में. Even the Hindu code which sought to create a uniform law governing all Hindus is not uniform. Even the Hindu code which sought to create a uniform law governing all Hindus is not uniform in some of the most fundamental aspects of family law. The validity of marriage is linked to the customs and ceremonies of the particular community. The inheritance rights of the members of family is different for communities in Kerala and Tamil Nadu. Who is capable of being adopted also depends on the custom and usage. The Hindu Minority and Guardianship Act 1956 does not automatically apply to members of scheduled tribes. The claim that since Hindus, अब जो claim करते ये UCC होना बोल के, the claim that since Hindus are governed by uniform law, why not everyone else falls flat? Why not everyone else जो बोलते, it falls flat at the very first step. The law is not uniform for all Hindus in the first place. While no doubt the Hindu code makes several aspects of Hindu personal law uniform, it leaves custom and local practice undisturbed in several aspects. अब बीजेपी के UCC के बोलते है ना, गोवा में है. Even the much touted example UCC, the Portuguese Civil Procedure Act 1939, applicable to all communities in Goa, इसमें भी exception है. क्या exception है? It has different rules for Catholics, different rules for other communities, and it even recognizes bigamy for Hindus. अगर कोई हिंदू लेडी को 25 और 30 साल के दौरान बेटा नहीं हुआ तो उनके हस्बैंड सेकंड शादी कर सकते गोवा में, ये उसमें है. If UCC, Justice V. Gowda साहब लिख रहे, if UCC is really about uniformity, it will remove the requirement of religious ceremonies for the validity of marriages, abolish the concept of co-parcenary property, and remove all distinctions between converts and non-converts over the inheritance property. देखो आप, remove distinction between converts. हिंदू मैरिज लॉ में डिवोर्स का ग्राउंड है कि अगर के हस्बैंड एंड वाइफ कन्वर्ट हो गए, वो डिवोर्स का ग्राउंड है. डिवोर्स का ग्राउंड है वो भी. If uniformity in all respects is not desirable, then that is an acknowledgement of the folly of promoting UCC without understanding the specifics of what it entails. If the goal is to address inequities in personal law of different religions, such inequities must be addressed on their own terms instead of demanding adherence to UCC. Whether it is the courts, the Constituent Assembly, or even those who are proposing the UCC as a panacea to gender inequality in laws or national integrity, no one seems to have a clear conception of what a court would actually look like. तो ये हमारा नोट जस्टिस वी गोपाला गौड़ा, ऑनरेबल जस्टिस वी गोपाला गौड़ा साहब का लीगल ओपिनियन, और हम जो पोजीशन पेपर दिए थे 2018 में 21st लॉ कमीशन को, वो सब ये बता रहा है कि यूसीसी की इस देश को जरूरत नहीं है. और अगर आपको मेरी बात का यकीन नहीं है तो जस्टिस BS चौहान जो 21st लॉ कमीशन में क्या बोले थे वो भी सुन लो आप, वरना आप लोग ब्रेकिंग न्यूज बोल के ओवैसी को सूली पे चढ़ा देंगे. कल्चरल डाइवर्सिटी कैनॉट बी कॉम्प्रोमाइज टू द एक्सटेंट दैट आवर अर्ज फॉर यूनिफॉर्मिटी इन इटसेल्फ बिकम्स अ रीजन फॉर थ्रेट टू द टेरिटोरियल इंटीग्रिटी ऑफ द नेशन. इतना बड़ा स्टेटमेंट जस्टिस BS चौहान दिए थे. ये है चीज़ है. तो आपको इंशाल्लाह अभी आपको हमारे लोग ये पूरे नोट्स जो हमारा रिप्लाई है लॉ कमीशन को आपको दे देंगे. आप लोग आराम से पढ़िए उसको, और मुझे यकीन है कि आपके पढ़ने के बाद आपके जहन में कोई सवाल पैदा नहीं होंगे.
सर, ये डाइवर्सिटी की बात आप कर रहे हैं.
नहीं, मैं आप अगर पढ़ने के बाद, अभी तो पूछ लो आप, मैं बैठा ज़रूर हूँ. पढ़ने के बाद अगर आप पूरे इखलास के साथ उसको पढ़ेंगे, पूरी सिंसियरिटी के साथ आप पढ़ेंगे, तो आप पोजीशन समझेंगे हमारा, आप पोजीशन समझेंगे. देखिए, जब आप मेरे को देखते ना, आप मेरे को देखते तो मैं आपके साथ क्यों बन जाऊं? आप मेरे साथ क्यों बन जाएंगे? आप मेरे को देखो, हाँ भाई, मैं एक इंडियन मुस्लिम हूं, एक आदिवासी है. आप कैसा अपना ओपिनियन आदिवासी पे डालेंगे, एक मुस्लिम पे डालेंगे? अच्छा, मुसलमानों में शिया भी है, उनका जाफरी स्कूल ऑफ थॉट है. मुसलमानों में हनफी है, शाफाई है. यूनिफॉर्म सिविल कोड की आप बात कर रहे, अभी मिताक्षरा स्कूल ऑफ थॉट है उसमें ज्यादातर, वो उसमें दया भागा लेके आएंगे क्या आप लोग? बोलो हमारे को।
मिडिल ग्राउंड क्यों नहीं देखने?
नहीं नहीं, मिडिल देखिए, मिडिल ग्राउंड देखिए।
क्योंकि डाइवर्सिटी है।
आपका सवाल क्या है?
डाइवर्सिटी है, सही बात है, लेकिन
आपका सवाल बोलो मेरे को आप। नहीं नहीं, आप ओपिनियन, आपका सवाल बोलो।
यूनिफॉर्मिटी क्यों नहीं देखते? आपके सजेशंस में यूनिफॉर्मिटी क्यों नहीं देखते?
अच्छा सुनिए,
सब डिलीजन
एक आप बोल दिए ना, सुनो। इसका सवाल ये है ना, स्पेशल मैरिज एक्ट है, यूनिफॉर्मिटी नहीं आ रही उसमें।
अभी नया बना है।
अरे स्पेशल मैरिज एक्ट है, जुवेनाइल जस्टिस एक्ट है, इंडियन सक्सेशन एक्ट है, आप ले लो, उसको इस्तेमाल करो ना, क्यों नहीं कर रहे? स्पेशल मैरिज एक्ट में भी आप सक्सेशन में एग्जेम्पशन दे दिए, उसमें मुसलमान नहीं आते। अब उसमें एक्सेप्शन दे दिए, या आदिवासी अप्लाई नहीं होता। स्पेशल मैरिज एक्ट है, अब यूनिफॉर्मिटी के आप बोल रहे। जुवेनाइल जस्टिस एक्ट है, इंडियन सक्सेशन एक्ट है आपका, ने इस्तेमाल करो ना आप।
तो सभी को एक कॉमन ग्राउंड में लाना
नहीं, सबको देखिए, सबके लिए है वो स्पेशल।
यूनिफॉर्मिटी लाएंगे।
नहीं, कैसा लेके आएंगे आप, बोलो आप।
सजेशन
नहीं, अरे आप देखिए, लॉ कमीशन तो कुछ सामने रख रहा ही नहीं। 21 लॉ कमीशन जो वर्किंग पेपर रखा था, उसके बाद उन्होंने खुद बोल दिए, द कल्चरल डाइवर्सिटी कैन नॉट बी कॉम्प्रोमाइज टू द एक्सटेंट दैट आर अर्ज फॉर यूनिफॉर्मिटी इटसेल्फ बिकम्स अ रीजन फॉर अ थ्रेट टू द टेरिटोरियल इंटीग्रिटी ऑफ द नेशन। आप यूनिफॉर्म की बात कर रहे, जस्टिस BS चौहान अपनी रिपोर्ट में बोल रहे कि यूनिफॉर्मिटी इटसेल्फ बिकम्स अ रीजन फॉर अ थ्रेट टू द टेरिटोरियल इंटीग्रिटी ऑफ द नेशन। मैं अपनी बात करने से पहले आपसे ये बताना चाहूँगा कि हम लोग जो 22nd लॉ कमीशन को जो अपना नोट या रिस्पॉन्स लिखकर भिजाए, उसमें 3 चीज़ें हैं। एक तो एक रिस्पॉन्स नोट है, दूसरा उसमें हम रिटायर्ड जस्टिस वी गोपाल गौड़ा का एक लीगल ओपिनियन जो हम उनसे पूछे 5 क्वेश्चन के ऊपर, वो भी हम उसमें देंगे। और तीसरा हम उसमें एक पोजीशन पेपर में जो 2016 में 21 लॉ कमीशन को दिया था, वो तीनों हम लोग लॉ कमीशन को आज भिजा चुके हैं। तो सबसे पहले ये है कि मैं शुरुआत में मैं शुक्रगुजार रहूँगा हमारे सुप्रीम कोर्ट के फाजिल वकील जनाब एडवोकेट निज़ाम पाशा साहब का, कि उन्होंने हमारी बहुत मदद की इस रिस्पॉन्स नोट को तैयार करने में, बल्कि उनकी बहुत ज़्यादा मेहनत उन्हीं की रही, पूरा उन्हीं का पूरी इसमें जुस्तजू थी, मेहनत थी, और उनके ताउन से उनकी पूरी मदद से ये एक रिस्पॉन्स नोट हम तैयार करें। तो अब इंशाल्लाह अभी आपको एक थोड़ी देर में ये तीनों नोट्स हम लोग आपको दे देंगे। मेरी आपसे गुजारिश ये है कि मेरे को थोड़ा टाइम दीजिए आपको पढ़ के सुनाने के लिए, वरना अगर आप शॉर्ट में चाह रहे तो मैं दे देता हूँ ये आप लोगों को, क्योंकि मैं ये चाह रहा हूँ कि आप
3.8
नहीं 3 पॉइंट नहीं है, वो ऐसा नहीं है आशीष। देखिए, ये 2 मिनट बाइट नहीं हो सकता, तो आप सुन लीजिए एक 10 मिनट के लिए मेरी बात को, और उसके बाद आप लोग जो भी सवाल करना है करिए। तो सबसे पहली बात तो ये है कि ये जो नोटिफिकेशन 22nd लॉ कमीशन का आया था जून 14 को, जिसमें उन्होंने पूछा कि व्यूज़ दीजिए ऑन द इशू ऑफ यूनिफॉर्म सिविल कोड, मगर उस नोटिफिकेशन में लॉ कमीशन कोई प्रपोजल नहीं देता, सिर्फ उसमें हवाला देता 21 लॉ कमीशन का। और 21 लॉ कमीशन जो कंसल्टेशन ऑन पेपर ऑन रिफॉर्म्स ऑफ फैमिली लॉ दिया था 31 अगस्त 2018 को, वही उसका हवाला दे रहे उन्होंने, और उसका जवाब हम दे चुके एज अ हमारी पार्टी तरफ से। तो ये सबसे बड़ी उसमें गलती है, और ये कोई कोइंसिडेंस नहीं है कि एग्जैक्टली 5 साल के बाद फिर से लॉ कमीशन ये एक्सरसाइज को अंडरटेक कर रहा है UCC के बारे में। माने क्लॉकवर्क की तरह हर जनरल इलेक्शन से 5-6 महीने पहले भारतीय जनता पार्टी इस इशू को उठाती है, यूसीसी को, और मकसद एक ही है कि एटमॉस्फेयर को विशेड करना, पोलराइज करना इलेक्टोरेट को, ताकि आने वाले जो 2024 के चुनाव है उसमें उनको कोई सियासी फ़ायदा मिल सके। अब आप ये समझिए कि जून 14, 2023 को जो उन्होंने पूछा यूनिफॉर्म सिविल कोड के बारे में, हाँ, मगर वही कंसल्टेशन पेपर के बाद जस्टिस चौहान साहब क्या बोले, दैट अ यूनिफॉर्म सिविल कोड इज नीदर नेसेसरी नॉट डिजायरेबल एट दिस स्टेज। ये बोले उन्होंने। ये यानी इनका कॉन्ट्रोडिक्शन देखो आप 22 लॉ कमीशन का। और दूसरी बात ये है, वो उन्हें बताते भी नहीं कि व्हाट इज अ यूनिफॉर्म सिविल कोड। ये जो 22वां लॉ कमीशन है, बताते भी नहीं व्हाट इज अ यूनिफॉर्म सिविल कोड। 21वां लॉ कमीशन चौहान साहब का, तो वो तो अलग ही ओपिनियन दिए, ये नहीं बताते। अब आप आ जाइए कॉन्स्टिट्यूएंट असेंबली के डिबेट्स के ऊपर, जिसमें इसमें एक साफ तौर से कहा गया था बाबा साहेब अम्बेडकर के बारे में, अम्बेडकर ने कहा था, मैं आपको पढ़ के सुनाता हूं। वन ऑफ द सॉल्यूशन प्रपोज्ड बाय Baba Saheb Ambedkar was that Parliament may make the Uniform Civil Code optional. It will be available to persons who wish to opt out of their personal laws. Dr. Ambedkar further assured the members of Constituent Assembly that, therefore, no one need to be apprehensive of the fact that if the state has the power, the state will immediately proceed to execute or enforce that power in a manner that may be found to be objectionable by the Muslims or by Christians or by any other community in India. We must all remember, including members of Muslim community who have spoken on the subject, though no one can appreciate their feelings very well, that sovereignty is always limited, no matter even if you assert that it is unlimited, because sovereignty in the exercise of that power must reconcile with itself the sentiments of different communities. अब important सुनिए आप, no government can exercise its power in such a manner as to provoke the Muslim community to rise in rebellion. I think it would be a mad government if it did so, but that is a matter which relates to exercise of power and not to the power itself. So, इससे it is clear from the text of Article 44 itself, as the debates in Constituent Assembly, that UCC was contemplated an exercise that involved disruption and upheaval to yield one size fits all, and therefore notes of caution were sounded, including the need for it to temper with optionality. ये एक है। दूसरी बात ये है कि the reform of specific personal laws of individual religious communities proposed in the consultation paper, यानी consultation of 21st Law Commission, that it finds its basis not in Article 44 but in entry 5 of list 3 of 7th schedule of the Constitution. Such an exercise of codification or alteration of individual laws of individual communities requires a more focused consultative process, with draft laws being placed for comment and the participation of stakeholders from the affected communities being sought. As such, the consultation paper, just by virtue of sheer breadth of issues it has covered, was grossly unequal to the task it set out for itself. अब आप ये देख लीजिए, इसका तो कोई कॉन्स्टिट्यूशनल बेसिस नहीं है, मगर हमारा मानना ये है कि ये एक पॉलिटिकल एक्सरसाइज हो रही है, एक गैर ज़रूरी के एक माहौल को मुल्क में पैदा करने के लिए लोकसभा इलेक्शन से पहले, ताकि जो तवज्जो है जनता की गरीबी के ऊपर, बेरोज़गारी के ऊपर, महंगाई के ऊपर, चाइना जो ज़मीन पे हमारे कब्ज़ा करके बैठा, उससे तवज्जो हटा दिया जाए। और हमारा मानना ये, हमारा एप्रीहेंशन ये है कि deliberately uniforms, there is a reasonable apprehension that by deliberately confounding the difference between UCC on the one hand and piecemeal reform of family law on the other, the present government wishes to avoid political consequences of obliterating the diverse customs prevailing in various Hindu communities that are presently protected under various applicable statutes, avoid dealing with tribal practices that have been granted protection or a constitutional scheme, and skirt the issue of tax benefits available to the Hindu undivided family, each of which is necessary concomitant of a UCC that is enforced throughout the territory of India. Instead, it is reasonably feared that such an exercise will merely isolate Muslim personal laws and subject them to a reform process solely for political gain, and justify this process as being in furtherance of mandate Article 44, thus claim fulfillment to claim fulfillment of election promise. अब आप ये देख लीजिए, अब ये उत्तराखंड में जो हो रहा है, एक कमेटी बनाई गई, कमेटी ऑफ एक्सपर्ट्स ऑन लॉज रेगुलेटिंग पर्सनल सिविल मैटर्स, यूसीसी उत्तराखंड, वो एक नोटिफिकेशन दिए 27 मई 22 का. हमारा मानना ये है, इट इज नॉट इन फर्दरेंस ऑफ आर्टिकल 44 of the constitution. Any code of law applicable only to one state is by its very definition not uniform throughout the territory of India, which is the clear language of Article 44. Therefore, it is clear that both at the center as well as the state level, the bogey of UCC is being raised only to target the Muslim community and polarize the atmosphere of political mileage. अब आप ये देख लीजिए, हमारा जो अब प्रीवियस ऑब्जेक्शन का फर्स्ट पॉइंट क्या है, इस देश में इमेंस डाइवर्सिटी है विद इन वेरियस ग्रुप्स और द लीगल ट्रीटमेंट. अच्छा, जो लीगल ट्रीटमेंट विच इज मेटेड आउट टू कल्चरल कम्युनिटीज डिफर्स इमेंसली and is non-uniform. For example, Muslims and Christian citizens of the country cannot access tax rebate under Income Tax Act available to Hindu undivided families. This reflects not only a mistreatment of how Muslim and Christians are treated in the country, but also reflects how accumulation of caste capital continues to receive legislative and constitutional protection. It is obvious that Adivasi and Dalit communities do not have access to accumulated intergenerational capital and therefore cannot seek taxation benefits under existing legislation. Secondly, the term UCC appears in directive principles. The law commission has not clarified again how uniform is confused with the common civil code. It must be emphasized that our constitution makers clearly noted that code will never be imposed on citizenry merely because of citizens. Third, unlike Hindu law, which operates on strictly priestly and legislative interpretation, Islamic law, along with Adivasi and Dalit social practices, is not uniform and extremely contingent on context, cultural practice, social relations. Therefore, one sees that despite a permission of polygamy in the community, Muslims in practice rarely practice it. In other words, Muslim personal law and equal gender rights are never seen as contradictory but consistent with each other in practice. Fifthly, for codified Hindu law, family and social relations are extremely diverse within communities. For example, in Hindu Marriage Act under Section 2 recognize the rights of Adivasi communities to continue practicing their own customary law. Similarly, within Muslim various groups and subgroups observe extremely varying practices. Each of these practices is considered by such groups to be within the umbrella of Sharia or Muslim personal law. Such communities include sects such as Shia, Sunni, but also cultural groups such as Kachi Memons and Mapila Muslims, and schools of thought, Hanafi, Jafari, Salafi, and other denominational schools of thought. Each of these groups' practices are influenced by each of these aspects. What are the aspects? And they cannot be classified into single monolith identity. The diversity of the country is too vast to be raised by single legislation of parliament. 6. Codification of personal law does not equate with equal rights. Besides the example, it must be noted that Hindu Marriage Act 1956 does not recognize that parties to marriage must exercise their consent. इस्लाम में कबूल है पूछते आपको, हिंदुइज्म में कबूल है नहीं पूछते, आपके रिचुअल्स जो मुकम्मल हो जाते शादी हो जाती. Number 1. However, it are completed a valid marriage. However, under Muslim personal law, unless the parties agree to marry each other, no marriage is valid. Any vitiation of consent makes a marriage void in Islam. 7th, a voluntary, secular, non-religious civil code already exists in the statute books in the form of SMA, JJ Act 2000, Indian Succession Act 1925. However, it is recommended a voluntary personal law system also be recognized. आप recognize करो इसको. Any community that seeks to preserve its distinct religious culture and social practices under Article 25 and 29 of the Constitution must have the legal avenue to do so. 8. The operation of Muslim personal law shows that it is far more progressive than positive statutory laws like Hindu Marriage Act. In awarding maintenance and ensuring social care of women, relevant studies show that women received a significant better deal under Muslim personal law than under laws. The abolition of such progressive and protective measures for Muslim women solely for achieving Superficial uniformity will result in absurd amount of injustice to Muslim women. Finally, the impact of abolishing personal and customary laws will not only be felt by Muslim communities in the country, but will also harm constitutional protection guaranteed to citizens of the country. These include constitutional protection to Nagaland, Mizoram under Article 371A, 371G. Furthermore, cultural rights of Adivasi groups under Schedule 6 Constitution are also violated by any common civil code. In addition to religious rights protected under Article 25 of the Constitution, the most significant violation will be Article 29 of the Constitution. अब आप आखिर में देख लीजिए कि the UCC debate is ingrained bias in favor of the religious morality of the majority community. ये पूरा UCC का जो डिबेट है रिलीजियस मेजॉरिटी ऑफ मेजॉरिटी कम्युनिटी को आप इंपोज करना चाह रहे सबके ऊपर. द स्टार्केस्ट एग्जांपल ऑफ दिस इज द लॉ ऑफ डिवोर्स. इसका एग्जांपल दे रहा हूं आपको. जो कंसल्टेशन पेपर 21st लॉ कमीशन दिया था, कंसल्टेशन पेपर proposes that unilateral divorce by a Muslim man should be penalized. The debate in public domain has vilified unilateral divorce, which in turn has prompted petition Supreme Court challenging talaq-e-ahsan, talaq-e-hasan. The two, अब दो ही बचे हुए, the two remaining forms of unilateral divorce by Muslim man. हम ये क्यों बोल रहे? The underlying assumption debate has always been the process of divorce under Hindu Marriage Act 1956 is a superior method. यही तो बोल रहा मेजॉरिटी जो मोरालिटी है. When one more or more of adultery, cruelty, desertion, unsoundness of mind or conversion or other faith has to be alleged and proved before a court in trial before divorce can be granted. हिंदू मैरिज एक्ट में आपको बताना पड़ता है adultery, cruelty, desertion, unsoundness of mind, conversion to other faith और उसको कोर्ट में प्रूफ करना पड़ता है before divorce is granted. Similarly, grounds are seen in Divorce Act of 1869 of Christians. This applies to divorce between Christian and Special Marriage Act that is usually cited as a shining example of egalitarian uniform law. अब आप इस्लाम में क्या है देख लो आप. इस्लाम में ये है कि पहले तो आप हिंदुइज्म में हम बता दिए आपको कि for cause divorce is intrinsically linked to the religious morality of Hinduism as practiced in many parts of northern India, under which marriage is sacrament that is meant for 7 lifetimes, as well as biblical idea of marriage as a vow before God to be together till death do us apart. In this understanding of marriage, a judge sitting as arbiter of societal morality must find the existence of grave intervening circumstances, which most oftenly qualifies as sin or curse in religion, before the marriage can be dissolved. This is in stark contrast to the Muslim personal law, under which the basis of divorce is the inability of spouses to live together or the choices of either of them to dissolve the marital tie and move on rather than determination of cause or arbitration of guilt. This is in consonance, ये जो Muslim personal law में जो divorce की practice है, this is in consonance with our constitutional morality that has consistently moved in direction of being pro-choice. अब कौन सा एग्जाम्पल है वो? सुप्रीम कोर्ट का केस है, शक्ति वाहिनी यूनियन ऑफ इंडिया 2018. Supreme Court said it has been sublimely borne in mind that when two adults consensually